Thank you for joining us today for the first of our webinars here at Cummingslaw. Today we're going to be talking about hedge fund structures and developments which have occurred recently in the hedge fund industry. My name is Claire Cummings and I'm the founder and partner in Cummingslaw, and I'm joined today by Ian Gobin.
My name is Ian Gobin, I'm a partner with Appleby and I'm based in our Guernsey office.
Well, I think the first thing to think about when you're setting up a hedge fund and the fund manager are the three guiding principles behind the structure. They are: who will your investors be, what the tax situation is so that your structure can be efficient, and what's the regulatory regime which will affect both the manager and the offshore fund. As I say, there are two elements. There's the manager in the UK and then there's a fund which will be overseas. And I'm going to talk mainly today about the manager and various hedge fund structures, and Ian will deal with the offshore elements. So going back to the UK and the FSA, Ian, you and I generally have managers who come to see us and the first thing they need to do is set up the FSA. The first thing I always have to explain is that the FSA regulates not just the investment manager, but also the people within the investment manager who will carry out what the FSA regard as a controlled function. So that's the manager, people who will be talking to clients in essence, and people who will be actually dealing or controlling client assets. The FSA application therefore includes forms and information both on the structure, so the company or LLP or possibly a combination of both, and also on the people who will be managing, owning and controlling the investment manager. When it comes to structuring a manager in the UK, from the offshore perspective, I'm not sure how many variations you see, but the most common one is to have a UK LLP, which is owned by the people who are behind the fund manager, and also have another member which is a limited company, and then the people who own that limited company will often be the same or some of the people who are partners in the LLP. Now, it's only the LLP which is going to be regulated by the FSA, though the limited company will be regulated to the extent that it is an owner of an FSA regulated entity. But the reason for doing it like this is because it allows the investment manager to take advantage of the tax regimes that apply to limited liability partnerships and also to limited liability companies. Now, in essence, a limited liability partnership is tax transparent, and the national insurance payments for contributions for partners are lower than those of employees. While at the limited company level, because it isn't transparent, you can start to roll up gains there and deal with distributions through dividend. And this is becoming particularly important in light of the recent tax increase to 50%, and I think will still be important when it's lowered to 45%. The next tax point is the investment manager exemption. Particular types of funds, and most hedge funds, have to be sure that the fund which they manage, albeit offshore, is not brought into the UK for tax purposes. And for this they have to meet the various loopholes which are available in the investment management exemption. And Ian, in a lot of the fund structuring that you see on the offshore side, there will be elements of the investment manager exemption coming in there too. The way the investment manager is paid: management fees and performance fees. The management fee should cover daily expenses, and the performance fee is the kicker for when things go well. Ian, what kind of structures have you been seeing recently in the performance fee structuring, and what kind of levels for management fee and performance fee?
I genuinely thought there would be some movement in respect of this over the last sort of 5-year period, but that doesn't really seem to have been much in the way of movement. So certainly a sort of 1.5%, 2% management fee and a 20% performance fee would be relatively standard. And
do you find, as we find, that the management fee is generally paid quarterly in arrears and the performance fee is annual, sometimes biannual if it's a particular trading strategy?
Again, there hasn't been really much movement in respect of that. That's absolutely what we see.
Yeah. And the other thing that I think we see, we probably agree on, that we both see more of, is equalisation rather than series accounting.
Certainly for European-based managers, then equalisation is the way forward.
Yeah, exactly. Moving on then to the actual fund structure itself. Well, there are possibly 5 more common hedge fund structures. The first is a standalone, where there are no US taxable investors, so the investors come into one fund which does all the trading. The second is a master feeder, so US taxable investors will go into a US LP, and non-US taxable and non-US investors go into an offshore feeder. Both then invest into the master fund, the offshore master fund. An umbrella fund and an SPC are both structures designed to allow for an element of segregation of assets and liabilities between different trading strategies. And then finally, there's a side-by-side structure, which in essence is having two standalone funds. It's just that one is invested in by US taxables, the second by everybody else. Block trades are put on and then allocations made between the two funds. Ian, I mentioned that the umbrella fund and the SPC fund are designed to give as much protection as each of those structures will allow for investment in different investment strategies. Over the last 10 years, there's been a definite increase in the use of SPCs. Perhaps you could talk about how an investor might invest in an SPC and how the segregation works under offshore law.
When it comes to SPCs or segregated portfolio companies, the main advantage really is that if the manager is going to be running a number of different trading strategies, they can do so through a number of segregated portfolios that are specifically set up to deal with the different investment strategies. So for example, if one segregated portfolio is set up that is running Asian equities, a second can be set up that is running European equities. You have legal segregation between the separate portfolios. This is a statutory segregation as compared to the traditional contractual segregation that you have between share classes in an ordinary fund structure.
So under Cayman law then, and it is for a Cayman fund or the relevant offshore jurisdiction law, and this is offshore law, not UK or US law, should your Asian equity strategy blow up and a lot of money is owed, it would not have an impact upon other strategies which are within the overall SPC structure, and they're able to continue trading unscathed.
That's right, and particularly when it comes to the segregation of assets between the segregated portfolios, there's been recent case law on this issue, so that the sovereignty between the portfolios has been maintained.
Right. So we've now talked about the structures which are generally available and those which are most commonly used. But of course, everything we've talked about so far has been a company or a partnership in the case of a USLP for US taxable investors. And companies are made up of shares. So the investors will invest in shares. Now, as one way of protecting the tax position of the fund and also of the fund manager in the UK, it's common to introduce two classes of shares. One will be a management or founder class of shares, which has virtually all the voting rights. And then the other will be the investment shares, which are the shares that the investors buy. These have fewer voting rights, which means that the fund can act nimbly and swiftly in any time of crisis, or just as a way of taking advantage of market conditions if any changes need to be made which impact upon shareholders. Ian, could you just, I think it might be useful if you could just elucidate a bit more on those rights which are kept for the managers or the founder shares and those rights which attach to investment shares to ensure that, as I say, the fund can act quickly if it needs to, but shareholders are still protected, so the investors have the protection which is required.
When setting up your average fund, generally an investment manager is not looking at giving away the voting rights to shareholders. Equally, many shareholders are not that interested in actually having or holding voting rights. So therefore the share classes are split between voting and non-voting, participating and non-participating. So for example, the voting non-participating shares could well be held by either the investment manager, subject to tax and regulatory advice, or in a Cayman Island Star Trust or a BVI Vista Trust in respect of those two jurisdictions, leaving the investors with the non-voting participating shares that could well be split up in different share classes depending on the fees regarding those different share classes. One thing that I should mention is that even where a shareholder has been issued with non-voting shares, their share classes cannot be, or rather their rights cannot be varied without their consent. So there will be provisions built into the articles and disclosed in the offering document in terms of the variation of rights that shareholders actually have.
And it's also worth mentioning perhaps that all investors in a particular share class have to be treated equally. So if, for example, you want to offer one set of investors a different liquidity rights or maybe a different fee structure, you would have to create a different share class for each of those investors.
That's right.
Yeah. Now, moving on to regulation, we've talked about the regulatory regime in the UK and we've talked about the FSA, albeit in brief. There have been changes in the offshore jurisdiction, in particular in Cayman, with the need for the Master Fund now to apply to the Cayman Islands Monetary Authority for regulation. Ian, you work in a number of offshore jurisdictions. Perhaps you could talk about the regulatory requirements in some of those jurisdictions and the developments such as the one we just talked about.
Certainly, when it comes to the Cayman Islands, we'll probably mention that first on the basis that the vast majority of hedge funds are actually set up and domiciled in the Cayman Islands. So when it comes to recent developments, then certainly in a master feeder structure, the actual fund itself would generally be regulated by the Cayman Islands Monetary Authority. And recently the master fund, I think as of January last year, the master fund is now required also to be regulated by the Cayman Islands Monetary Authority. There's still one offering document in respect of the master and the feeder. It's just that the master fund now has to fill in what's called an MF4 and pay an annual fee to the Cayman Islands Monetary Authority.
But while it's the master fund which appoints the trading counterparties, the administrator is appointed by both feeder funds and the master fund, because obviously it needs to calculate the NAV at both levels, and it needs to be able to deal with investors coming in at the feeder fund levels. And the investment manager is also appointed to all levels. While at the master fund it makes the crucial investment strategy decisions, at the feeder fund levels it will be in charge of deciding that the feeder funds invest in the master fund.
When it comes to the service providers that are appointed to the Cayman Islands registered mutual fund, certainly the administrator at the moment can be based absolutely anywhere. There is one thing that's come up recently, and that is the fact that if the administrator is based outside of the Cayman Islands, administrating the Cayman Fund either wholly or in part, then they are required to register with the Cayman Islands Monetary Authority and pay an annual fee as well as effectively an annual return. The auditor appointed to the fund can be based absolutely anywhere, save for the fact that when it comes to the sign-off of the financial statements, an auditor based in the Cayman Islands will be required to actually sign off. Alternatively, the auditor can be based in the Cayman Islands. Other than that, there are no requirements or any further requirements for service providers to be based in the Cayman Islands. Certainly the directors can be based absolutely anywhere.
So one thing that the directors of existing funds will need to ensure is that their administrator is aware of the new regulations coming into force and complies with them.
Absolutely. The directors of the existing funds need to be aware of this legislation and the fact that their administrator is adhering to the new registration regime.
And on the auditors, it's very common that the directors will appoint an auditor which will actually conduct the audit where the administrator lies, which is where the company books are, but then will be signed off in the Cayman office.
That's certainly one of the traditional routes.
Gotcha. If we can now move on to sort of maybe the wider aspect of marketing hedge funds. There's been a lot of talk since the crash of 2007, 2008 of the possible part that hedge funds have had to play in the wider global economic worries. Europe's reaction to this, that the European Parliament has to impose further regulation. And this has led to the drafting of the AIFMD, Alternative Investment Fund Managers Directive, for which we don't have the Level 2 directive, but Level 1 is in place. And we're all aware of some of the steps which the investment manager in the UK will need to take. Now, these will involve marketing, and there are slightly different rules which will apply to EU managers of offshore or non-EU alternative investment funds, and hedge funds will most likely be alternative investment funds subject to de minimis rules. Now, there are two schools of thought on how to prepare for the AIFMD. One is to take your offshore fund and move it into Europe and start preparing within Europe for the introduction in 2013. And certainly one of the questions that we've had in is on redomiciliation of offshore funds into the EU, which we will talk about. The other school of thought is to set up or remain offshore and continue to take advantage of the private placement regimes within the EU constituent countries and therefore avoid that additional layer of regulation. Are you finding that the AIFMD is affecting people's choice of whether to set up a non-EU fund or an EU-based fund?
I don't think it's affecting their choice at the moment. I think they're certainly aware of what the rules and regulations are at the moment, and indeed what they potentially will look like. In terms of investment managers drawing up a strategy to deal with a directive, it's a little early. Once stage 2 comes out, then the position will be a lot clearer, and managers as well as investors can see exactly where things are going. Certainly, over the last few years, some larger managers have been putting in place a strategy to deal with the directive, and some have pulled out of the Cayman Islands and re-domiciled in either Dublin or Luxembourg. But it's been few and far between. The vast majority of managers are sitting on this position at the moment, just waiting to see exactly how things will sort of pan out. But I would say that they're certainly going to be using the private placement regime going forward. That's one strategy that they can take. That the market seems to have taken the strategy of let's wait and see, let's continue with the private placement regime for as long as we possibly can.
Yeah. And it's worth bearing in mind that the AIFMD will still apply to the extent that the manager in Europe will need to be compliant with that layer of European regulation. On regulation, it's not just Europe, it's also America. There are huge regulations which have come and are coming in for the US, which are affecting fund managers. Is this something which you see applies to the setup of the funds or any offshore element, or is it really largely to do with the managers need to comply with US regulations rather than the funds need?
So far, the emphasis has been on the actual regulation of the investment manager rather than the underlying fund from a US perspective. So for as long as that continues, then there aren't any major offshore hurdles or issues that need to be climbed over. Okay.
Well, I think now we've still got time to deal with a couple of questions which people have sent in advance of our webinar. I mentioned earlier redomiciliations. Perhaps you can talk a bit about the general principles which are involved in redomiciling funds, not just from non-EU to EU, but also within various offshore jurisdictions as a whole.
Certainly from a Cayman Islands perspective, then you're looking at the usual corporate resolutions that will be required to migrate the company from the Cayman Islands to, for example, a European country. When it comes to the migration away from the Cayman Islands, then the fund itself will need to deregister from the Cayman Islands Monetary Authority, and it will have to become regulated again in the jurisdiction that it's domiciling to. For example, if it's moved from Cayman, it deregisters in Cayman, and it will have to register in, for example, Jersey or Guernsey. And it's actually far more likely that the fund will be redomiciling to either Luxembourg or Dublin as they're part of the EU, yeah, or indeed Malta.
Yeah. The second question we've had in is on restructuring. Specifically, what does a standalone fund need to do if it wants to turn into a master feeder fund so it can begin to take in US taxable investors, or indeed convert into an SPC for commercial reasons? As with everything, tax advice needs to be taken, and shareholders will have to consent, and they need to be very aware of their own tax position. The general mechanics which are often used for this kind of restructuring are for the shareholders in the existing fund to subscribe for shares in the new fund, but make that an in-specie subscription. So instead of stumping up cash for the shares, they subscribe by the shares in the existing fund, and that means that the positions which the master fund, which it will become, already has, will remain traded. They won't be redeemed. But that can be, for some investors, depending on where they are and what the tax regime which applies to them is, a crystallisation event, and tax advice needs to be taken. Ian, what other points are there to consider in restructurings?
One question that comes up a lot is how can a fund take in US investors? And certainly in that situation, the fund needs to take US tax advice and also structuring advice in terms of the way forwards. But often you'll have, in a standalone structure, or indeed in a master feeder structure, will be a further entity established. Often this is the Delaware Partnership.
Yeah.
And you have American or US taxable investors coming into the Delaware entity that then invest into the fund directly.
Yeah, which will be, say, for a standalone fund, means that standalone becomes the master.
That's
and you're
right.
now in a position where the shareholders of the standalone have now become shareholders of the feeder fund. You've got new investors coming in the US, and you have your master feeder structure.
So the fund effectively runs two separate offering documents, or it can be, everything can be combined into one. But US counsel will be required to be appointed and advise in respect of this.
Well, Ian, thank you very much for joining in the webinar today, and thank you everybody who's joined us as well. If you'd like to know more about what we've talked about today, then you can go onto the Cummingslaw website, and in the tab marked Publications, see various client briefings on matters such as setting up hedge funds, FSA regulation and AIFMD to date. And if you'd like to contact either Ian or me, then on our respective websites you can find our email addresses and our telephone numbers. Ian, once again, thank you very much, and
absolute pleasure.
we look forward to hearing from people with questions. Thank you.
Thank you.